Supreme Court set aside the conviction and sentence of appellants and allowed the two appeals by setting aside impugned judgment of High Court dated 26 August 2011 and of Trial Court dated 10th of March 2003 in the matter of Abdul Wahid and another versus State of Rajasthan. Fahim Ahmed lodged FIR before the Makbara Police Station, Kota, Rajasthan on 25 June 1988 at 12:35 am. He stated that Ahsan Ali and himself were on way to residence of in-laws of Ahsan Ali in Nyapura around 10:40 p.m. While Ahsan Ali was talking to relatives in shop of brother-in-law, he was seen by accused Abdul Sattar and Abdul Wahid. This was noticed by Fahim Ahmed, who knew them, and also about strained relationship between Ahsan Ali on one hand and Abdul Sattar and Abdul Wahid on another hand. He suggested to Ahsan Ali that while returning home they should change the route. However, Ahsan Ali insisted on going through same route by which they had come. While returning, when they reached the place called Ghantaghar at around 12 midnight, suddenly accused Babu, Abdul Wahid, Abdul Sattar Aziz, Abdul Shakur Mandu, and Latur Ali accosted them and attacked Ahsan Ali and himself with knives. The first knife injury was inflicted by Babu on stomach of Hasan Ali, whereafter he fell down from motorcycle. Second injury was inflicted by Abdul Wahid on chest of Hasan Ali, also by knife. Abdul Sattar inflicted injury by a katar or a sword on the backside of Hasan Ali. Abdul Shakur and Aziz, who were also trying to inflict injuries on Hasan Ali, chased the informant Fahim Ahmed. He ran into Gauri Hotel Lane. When the two accused persons did not find Fahim Ahmed, they returned back and started assaulting Ehsan Ali. Informant somehow managed to escape and went to police station to lodge the first information. He stated Ehsan Ali was lying at place of occurrence in injured condition. Incident witnessed by Wahid and Jamil. He alleged that due to previous enmity, the above named seven accused persons formed an unlawful assembly whereafter they assaulted Ehsan Ali with a murderous intent. On basis of FIR was registered on 25 June under section 147, 148, 149, 307 IPC. Injured Hassan Ali was taken to hospital for treatment but succumbed to his injuries, whereafter section 302 IPC was added to FIR. It had also come on record that Supreme Court, while according to prosecution witnesses 1, 3 and 4, there were about 100 to 150 people at crime scene. When PW 17 went to place of occurrence immediately after lodging of FIR, he did not find anyone there. That apart, it is quite unnatural that policemen in police station did not hear any noise when such a gruesome assault had taken place only about 300 to 400 steps away from the police station. Certainly, Hassan would have screamed on being so brutally assaulted. In fact, it has come on record that accused person had yelled warning the crowd not to interfere. It is therefore quite inconceivable that inmates of police station would not have heard the commotion from so near a place. If there were indeed 100 to 150 people present, they would not have remained mute spectators to such a gruesome assault. But this narrative of there being a crowd at crime scene had been proved false through the evidence of prosecution witness 17 and 20 who deposed that when they reached the crime scene, minutes after incident of lodging of FIR, they did not find anybody there and that there was all pervading silence. Supreme Court stated that according to prosecution witness 1, it was ASI who had taken the injured Hassan to hospital in an auto rickshaw. It is very unusual that prosecution witness 1 did not accompany the injured Hassan to hospital. Instead, he said that he was asked by ASI to take the motorcycle to police station. This is also not at all believable because if at all motorcycle was required to be taken to police station for investigation, it would have been taken by policemen and not by prosecution witness 1. On other hand, PW 17 in his evidence stated that he had sent ASI Ram Prasad along with team of policemen to place of occurrence on receipt of FIR. When he received information that his son was lying injured, he went to the spot himself and took injured to hospital, leaving a constable behind to guard the crime scene. Where did PW1 go? PW70 did not say that PW1 accompanied him to hospital, neither did prosecution witness 1 say so. Such glaring inconsistency clearly impeached very credibility of PW1 and has cast deep shadow over the prosecution case. There is no doubt the death of Ehsan is homicidal. Medical evidence has also confirmed multiple stab injuries on his body, leading to profuse bleeding and death. According to prosecution, it is accused who had committed murder of Ehsan. Therefore, it is for prosecution to connect the accused to murder of the deceased by producing credible and legally admissible evidence. However, the court said that we have seen there is no credible evidence at all to connect the accused person with homicidal death of Ehsan. In such circumstances, the appellants were entitled to benefit of doubt.